We are recording.
All right, thank you. Good afternoon. The Appellate Court for the State of Connecticut is back in session. We will now hear the matter of Property Tax Management, LLC versus Worldwide Properties, LLC et al., AC 43682. I am Judge Mall. I have the pleasure of sitting this afternoon with Judge Cradle and Judge Pellegrino. Because we are still in the midst of a pandemic, we are conducting this hearing virtually using the Microsoft Teams platform. Before I have everyone state their appearances, let me alert or otherwise remind everyone that this argument is being live streamed on the Judicial Branch's channel on YouTube. Accordingly, to the extent this case involves any protected identifying information that should not be disclosed, counsel are reminded to be careful not to disclose such information during argument. I would now ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, then counsel for the appellee. Again, I am Judge Mall. I'm Judge Cradle. Oh, Judge Pellegrino, you were on mute. All right, you're still on mute. All right, if you see the microphone, it should be on the top of your screen. It might be on the bottom. You just click that. All right, Judge Pellegrino, can you hear us? Yes, all right, I see you.
Can you hear me now?
Perfect, yes.
All right, good. Sorry.
That's all right. All right, counsel.
Good afternoon. My name is Bill Govea, and I'm the attorney for the defendant's appellant in this case. My practice is at 44 Lion Terrace in Bridgeport, Connecticut, and this case involves.
I'm sorry, counsel. We're just putting appearances on the record, so thank you.
My apologies.
That's all right. Counsel for the appellee, if you would just identify yourself. Thank you.
Good afternoon. My name is Linda Lasky. I am an attorney at the law offices of Green and Gross in Bridgeport, and I represent the Plaintiff Property Tax Management, LLC.
All right, counsel, prior to this argument, you should have received procedural instructions. Do you have any questions about those instructions?
No, Your Honor.
No, Your Honor.
No? Okay. All right, a few additional preliminaries. When you are not speaking, if you would kindly turn off your mic while leaving on your video, we want to ensure that we don't lose anyone. Also, let me state the obvious. When you are not speaking, kindly comport yourself as though we were in the physical courtroom, trying to avoid anything that might be distracting to either the court or opposing counsel. Each side will be permitted 20 minutes of argument. The appellant can, of course, reserve a portion of that time for rebuttal. Just let me know if you wish to do so and how much time. So, Attorney Govea, are you ready to proceed?
I am, Your Honor.
All right, you may do so.
My name, may it please the court, my name is Bill Govea, law offices at 44 Lion Terrace in Bridgeport, Connecticut. This appeal involves the enforceability of an agreement where a tax consultant, for a fee, a percentage of the tax reductions, takes over the entire tax appeal process. The defendant's position is that this agreement is unenforceable because it engages in the unauthorized practice of law and it violates several public policies. One, it is an unauthorized practice of law. A lawyer must abide by a client's decisions concerning the objectives of representation. A lawyer must maintain confidentiality. A lawyer must keep a client informed, and a person other than a party litigant cannot profit or participate in the proceeds of litigation. And it is a criminal act to practice without license. Because this agreement violates the public policy, the agreement is not entitled to compensation, and because he is deemed to be a party delito. Black's Law Dictionary, 5th edition, defines practice of law, and I would quote, the rendition of services requiring the knowledge and application of legal principles and technique to serve the interest of another with his consent. In Connecticut, in deciding whether one is practicing law, one focuses on whether the acts performed were of such as are commonly understood to be the practice of law. One also considers the facts and determines if it falls within the quote-unquote fair intendment of the term. There is a case in Connecticut, and that's Grievance Committee of Bar of Fairfield County versus Dacey. Mr. Dacey published a book about wills and trusts and with forms. And the court observes that publishing in of itself is deemed to be general information. However, when the forms were either used or altered for the purpose of meeting individual needs, that took the general information into the realm of quote-unquote practice of law. Connecticut Practice Book 2-44, capital A, parentheses A, close parentheses, defines the practice law as ministering to the legal needs of another and applying legal principles and judgment to the circumstances or objectives of that person, including giving advice or counsel. Other jurisdictions shed light on this, and there are two varieties. One is what I call character, and the other one is elements of the problem. New Jersey falls into the character states, and in New Jersey, requests that one look at the character of the acts performed, and if there is legal knowledge, training, skill, or ability, then it's deemed to be the practice of law. And that's the Stack versus PG Garage Inc. at 7 New Jersey 118, and it's 80 Atlantic 2nd 545. The other variety of analysis looks at the problem and if looks for elements of the legal practice. And if it finds that it requires legal training, legal analysis, legal judgments, civil procedure, or pleadings, then it's deemed to be the practice of law. Now, it doesn't require that all these elements be present, but just that one or more of the elements be present. And for this proposition would be Westmoreland County versus RTA Group, Inc. This is a Pennsylvania case. There's also a Pennsylvania case that essentially says if the person is merely assisting in with fact finding that there are no trials, there is no evidence, and requires merely lay judgment, then that's not the practice of law. In my review, all sister states state that each time that a tax consultant needed to evaluate legal consequences, he or she was deemed to quote-unquote practice law. In our case, legal rights were affected. The only two attorney witnesses testified to this, Mr. Liskoff at page 16, Mr. Antoniani at page 75 of the transcript of October 31st, 2019. Clearly, the plaintiff needed to assess legal consequences. He hired Attorney Antoniani to file at Superior Court. This alone is sufficient to establish that he practiced law. When a consultant engaged an attorney for representation of the property owner, he was deemed to practice law. That's the Stark case. Mr. Ternani was hired by the plaintiff, was the one that signed the stipulation upon the plaintiff's instructions. The mere fact that an attorney had to sign an agreement between tax authorities and property owner was deemed to be the practice of law. That would be Gallagher versus First Dependable Mortgage Co. Inc. at 255 New Jersey, sub 568, in the West citation 605 Atlantic 2nd, 785. Plaintiff made decisions to appeal. This is of itself a practice of law, and that's the Westmoreland County versus Roger case. The plaintiff admitted that he had sole discretion of litigation. That's page 5. He exerted all the control and all the discretion. That's at page 62. He had total control in that the property owner had no discretion. That's at page 42. All these references are to the transcript of October 30th, 2019. The plaintiff's acts are within the fair intendment of the term practice of law and are commonly understood to be, quote unquote, the practice of law. The plaintiff ministered to the legal needs of the defendants. The fact that he hired Mr. Tenani does not diminish the fact that he practiced law. Judge Stem missed the point. He focused on the control of the agreement permitted the defendants to terminate upon payment of the cost of a plaintiff. The point is practice of law, not the control to terminate the agreement. The practice law is the control over the litigation, which requires legal judgments, legal analysis, legal strategy, arguments, legal procedure, pre-trials, trials, settlement, and judgments. And the plaintiff participated and commended all of these items. The agreement assaults public policy. It can't and shouldn't be enforced on several grounds. It insults hallmarks of jurisprudence. Rule 1.2 of the professional conduct requires that a lawyer, quote, abide by a client's decisions concerning the objectives of representation and shall consult with the client as to the means by which they are to be pursued. A lawyer shall abide by a client's decision whether to settle the matter. This rule is very strict. The only window that I found within the rule, and I like to quote it, it says, quote, subject to revocation by the client and to the terms of the contract, a client's decision to settle a matter shall be implied where the lawyer is retained to represent the client by a third party obligated under the terms of the contract to provide the client with the defense and indemnity for the loss, and the third party elects to settle a matter without contribution by the client. This is the typical insurance contract. The insurance company hires a lawyer for the insured. He is presumed to, he is impliedly has authority to settle, but only when there are 4 or 5 elements. There's got to be an agreement, it's got to be indemnity, it's got to be a settlement, and there is no contribution requested from the insured party to the settlement. Here, we don't have any of that. The only elements that we have is a contract and a settlement. It's not for indemnity. On the contrary, Mr. Tenani was hired to prosecute a civil case. There is no contribution. On the contrary, the plaintiff is looking for compensation. It also violates confidentiality rule 1.6. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The issue of breach of confidentiality is squarely met on the Stack case. And I think I already cited Stack versus PG Garage Inc., 7 New Jersey, 118 at page 122 in the Atlantic, it's 80 Atlantic 2nd, 545. The courts had very strong concerns about this confidentiality in these types of agreements. The hiring of an attorney only exacerbated the situation. And I'd like to quote from that case. Such circumstances, however, operate not to relieve the plaintiff, but only to embroil the attorney in the legal scheme. If such subterfuge was permitted, it would result in the destruction of the confidential relationship that an attorney bears to his client. It would permit non-lawyers to engage in legal matters for others. A layman could obtain clients and then hire lawyers who are total strangers to the client to perform legal work. The conclusion is that the practice of law would destroy the confidence between the client and the attorney. It would thwart the control of the courts over the practice of law, and it would irreparably impair the sound administration of justice. It also violates Rule 1.4 of the Professional Conduct. A lawyer shall keep a client reasonably informed about the status of the matter. The lawyer needs to communicate with the client. Mr. Antignani was, quote unquote, technically representing defendants, but hired by the plaintiff. That's at page 74. Mr. Antignani's retainer was with the plaintiff, not with the defendants. That's at page 73. Mr. Antignani never met the defendants, their members, their managers, their officers, their shareholders, or at page 72. The agreements were reduced to judgment without presence, knowledge, or input from the defendants. That's at page 12. All these are in reference to transcript of October 31st, 2019. Mr. Antignani.
Attorney Gouveia, let me interject with a few questions if I could. So with regard to any judgments that were entered or agreements reached in the Superior Court, did your clients try to vacate those judgments or have rendered void any agreements?
No, Your Honor. He's a layperson. He did not know about the judgments, about the effect of the judgments. He only became aware of the judgments and of the agreements once he was presented with the bill.
But there's been no activity in the Superior Court with regard to those judgments?
No.
All right. And so another question I had was the damages award that was issued here vis-a-vis the various breach of contract counts. Did those amounts cover only services provided in connection with Superior Court matters, or did it also cover services rendered in connection with Board of Assessment appeals?
Both, Your Honor.
But with regard to those, you're only claiming that the unauthorized practice of law occurred once the Superior Court was going to be invoked?
Your Honor, in my brief, I made a mistake. I agreed that he had authority under Section 12, under a Statute 12-111A. That was a mistake. I'd like to discuss that with the court if permitted.
Well, I mean, have you made any kind of correction in a reply brief? I don't believe you.
No, I have not. I have not.
Well, counsel, you can't really change your theory of the case, during oral argument.
If I cannot, Your Honor. But as I thought after filing the brief, as I celebrated this case, thought through it, I realized that I made a mistake. There is cases on point to say that once you practice law, if it's unauthorized, whether it's at the level of the tax board or into Superior Court, you're practicing law. In fact, the there are cases on point from the Pennsylvania and from Ohio that take the similar language as the statute 12-111A and interpret party and persons as requiring an agent, but the agent must be a lawyer, cannot be any person.
All right, you have 3 minutes left out of your 20. Do you wish to reserve the balance for rebuttal? I mean, you can use it all up now. It's your choice.
I would like to use it right up now, Your Honor.
Okay.
This also violates the right of a litigant to the proceeds of his case. Rice versus Farrell prohibits the sharing of benefits of the litigation, and so does Biller Associates. Further, this case is by permitting the plaintiff committed a criminal conduct in violation of 51-88. He was practicing law without authority. I would submit that the section 12-111A and 244A's parentheses B, close parentheses 2, interprets an agent to be a person that has practiced as licensed to practice. The 244A requires permits a layperson to represent if confined to the agency and if there's a statute or rule. None of this was ever found to permit such activity. I submitted an ALR article that brings compiles cases on point. I would like to just bring to your attention that both Pennsylvania and Ohio prohibit this quote-unquote cottage industry. They ban it, and that's because even though the custom of having tax consultants, it may be a custom in Ohio, but it complies with custom, but it doesn't comply with the law. Finally, now that we established that he practiced law without authority and that he violated the policy, he's entitled to no damages. He's a party delicto, and the case for that would be Treat versus Jones and Biller versus Associates. He's not even entitled to quantum merit. There are 2 cases that I found in Connecticut where a lawyer licensed in Connecticut, in New York, but did the services in Connecticut, was not entitled to compensation for his services. That would be Taft versus Ensel at 180 Atlantic 2nd, 756, and it was not even entitled to quantum merit. The other case was in Rat Peterson. It's a bankruptcy case, 163 BR 665, but it's interpreting Connecticut law.
All right, Attorney Gouveia, your time has expired. So Attorney Lasky, you'll have 20 minutes. You may proceed. And Attorney Gouveia, I would just ask if you would kindly mute your microphone.
Thank you.
Thank you. All right, Attorney Lasky.
Thank you. Again, for the record, I'm Linda Lasky. I represent the plaintiff. I just want to respond at the outset to some points that Attorney Gouveia made before I sort of give you my different lens through which I hope the court will consider this case. First of all, there were several cases that were noted that were not cited in the defendant's brief. There was a matter of grievance committee versus Dacey, a case called Gallagher or something from New Jersey, and at least one other called Taft versus, I think he said Edsel, that I don't see in his statement of authorities. I don't recall seeing those in the brief at all, and I'm not familiar with those. And then just on a few points, I suppose basically what Attorney Gouveia is asking the court to do is to consider whether this involved the illegal practice of law. But really, I think what's maybe so obvious perhaps to me and to the trial court was that this is an agency contract, and the trial court made the finding that this is a contract of agency. Excuse me. The defendants were all corporations or limited liability companies. They had no means of acting at all except through an agent. Mr. Vole, who appeared as a witness in the trial court proceedings below, acted on behalf of the companies as their duly authorized agent in delegating powers to the plaintiff to undertake the tax consulting representation that was done. There's just simply nothing that is contrary to public policy in that. It could have been an employee of those companies, a subcontractor, a contractor, like this was an agency contract, whereby the plaintiff acted as attorney in fact, as agent to the defendants. And then on top of that, nothing that the plaintiff did involved anything that was contrary to public policy. And in fact, the type of tax consulting arrangement that's at issue in this case was virtually identical to one that was at issue in the case of Robertson versus the town of Stonington, where the Connecticut Supreme Court found, excuse me, that agreement was not contrary to public policy as a matter of law, so as to, in that case, void the right of the plaintiff, in that case, to take a tax appeal. By the same logic, if in the Stonington case, the Robertson case, the court had recognized there was an unconscionability issue or a violation of public policy that was so severe as to require that the underlying agreement between the plaintiff and the tax consultant was so problematic, then effectively the plaintiff could not have had standing to pursue the tax appeal in the matter below in the Robertson case. So the same here. If this agreement is so contrary to public policy, the plaintiff would not have had agency and been able to retain counsel to bring these appeals to get the benefit that ultimately resulted in benefits to the defendants. As you've heard, the defendants aren't challenging the results of the tax appeal. They received benefits. They haven't challenged the fact that Mr. Vole, on behalf of the defendants, entered into this agreement voluntarily with knowledge of the terms, which included, an express statement that no legal services would be provided, and that if legal services were needed, an attorney would be retained on behalf of the defendants. That was done. As I'm sure the court saw, there's specific authority in the general statutes, in the practice book, and in rules of court that contemplate agreements like this that allow a layperson to represent taxpayers in property tax appeals, in negotiating with taxing authorities, municipal taxing authorities, and in actually representing them directly at proceedings before boards of assessment appeal. That was done in this case. Specifically, excuse me, perhaps it might warrant some closer scrutiny to look at practice book section 2-44A that talks about the definition of the practice of law, which is ministering to the legal needs of another person and applying legal principles and judgment to the circumstances or objectives of that person. But even under 2-44A subsection B, certain activities, even if they would otherwise be considered the practice of law, which in this case, we would submit that they weren't, that the plaintiff merely acted as effectively an agent or attorney in fact on the factual question that's involved in these tax appeals, which is what is the value of the subject properties. But even if his actions were somehow, able to be deemed the practice of law, they would still be excluded under 2-44A subsections B to A and B, which expressly allow a layperson to be a representative in administrative proceedings and to engage in conduct that is reasonably ancillary to such representation, and also conduct that is authorized by statutes. And in this case, there are two relevant statutes. Well, Section 51-88 of the Connecticut General Statutes provides that a person who's not admitted as an attorney can act effectively in ways that would be considered the practice of law unless they're acting pursuant to statute or rule of superior court. And then as well, Section 12-111 is a statute that specifically authorizes a layperson to represent a taxpayer in proceedings involving the doings of municipal property tax assessors. And it probably warrants looking carefully at the language of 12-111A. Specifically, that statute contemplates, the legislature clearly contemplated that lay people could represent a taxpayer because the written appeal to a board of assessors Board of Assessment Appeals must include not only the property owner's name, but also the name and position of the person who's signing the appeal, which necessarily contemplates that it could be a person other than the property owner who's authorized by the property owner. It provides for the name and mailing address of the party to be sent all correspondence, which is not necessarily the same as the property owner. And it specifically provides that notice of the board's determination be sent to such person, not to the property owner, to such person who took the appeal on behalf of the property owner, if it has been the case. And that notice has to describe the property owner's right to appeal to court. So in the grand scheme, the entire statutory scheme, it's clear that the legislature contemplated, and it's consistent with the public policy, to allow a layperson to represent a property owner in negotiations. That's exactly what was done in this case. Negotiations with taxing authorities to appear in the proceedings before the taxing authorities and a board of assessment appeals, and then to continue those negotiations, as was done in this case, in the context of appeals to superior court that were brought with the authority of the corporate defendants in this case. So there's really no action that was undertaken by the defendants that could be deemed the practice of law. And again, even if it were somehow deemable the practice of law, the activities of the plaintiff were excluded under these statutes and rules of practice that I've just discussed. I would note as well that the case of Biller Associates is significant and it's readily distinguishable. In that case, there was a very specific statutory scheme that involves public adjusters that strictly limits the activities of public adjusters and their employment contracts to only permitting a public adjuster to represent a named insured under an insurance contract. In this case, that kind of scheme doesn't exist. There aren't that kind of limitation or stricture. And that I suppose in addition, in that case, the award from which the public adjuster sought to receive compensation was not even, there were no damages that were derived from insurance policy proceeds that were related to the fire insurance policy that the public adjuster contracted with the property owner about. It was proceeds from an errors and omissions insurance policy that the insurance agency had, and there was a lawsuit involving negligence of the agency for failing to name the proper person as the insured. So it's just a wholly different set of facts that does not apply here. I don't know if the court has any questions. I'd be happy to entertain any questions from the court.
All right, I don't see any questions from my colleagues. So counsel, thank you very much for your time and for participating in this virtual format. The court will take the matter under advisement, and the court is adjourned until tomorrow, March 9, 2021 at 9:30 a.m. Thank you.
Thank you, Your Honor.